Good afternoon. My name is Hal Emelfarb. I'm the founder and general counsel for National Lien and Bond. My law firm, Emelfarb, Swan & Bain, is in Highland Park, Illinois. And our firm was appointed general counsel in 1985. And the purpose of our role as general counsel, as many of you may know for National Lien and Bond, is to protect National Lien and Bond claim members' legal and compliance rights that they have on construction projects all over the United States and now recently in the last few years globally. So welcome to our seminar, How to Win a Construction Claim in 30 Minutes. I wish it would be this easy every time we have a claim, but we're going to summarize it and give you a very good introduction to strategy and when you can make a claim, what events are claimable, and how to make your claim compelling. That's the key participants. Because usually when a claim is initiated, as many of you know, the claims are not limited between you and your customer. In fact, this entire claims analysis and program and strategy on how to win a construction claim is really how to try to work with your customer if possible and team up with them so the two of you can jointly pursue your claim against the other parties, because typically that's the chemistry that we've seen. Not always, but that's typically what happens, particularly in the payment scenario. So the first thing we're going to discuss today is basically when we make a claim, you have to be honest with yourself and honest with the other person. So many people think by exaggerating, that's going to make your claim productive. In fact, you can support your claim with facts to make your claim stronger, but I strongly suggest you use the facts and details that we'll be talking about how to obtain and how to present to the other party. So when we focus on making claims as lawyers, we look at the individual parts of the claim, and really we like you, feel that our client, like you would feel, is wrong or right, but if you're making a claim. Many times people are making a claim against you where you feel somewhat defensive, but you feel strongly about your position. So we're here today to show you exactly what steps to make in the claim process and strategically how to proceed. So there's nothing worse than filing a claim that you're not prepared for and that you cannot prove, whether it's in court or arbitration or litigation or in mediation or even a conversation and negotiation. So claims come from all different places, as you know. Particularly they come from sometimes design errors in the plans. Now, when you look at a contract, you have expressed terms, a subcontract. When you are in the construction industry for more than a short period of time, you begin to hear of certain concepts. Before we start talking the details of provisions and pursuing claims and how to do so, one of the things I want you to be aware of is every construction contract, as well as every commercial contract in the United States, has an implied duty of good faith. Why are there implied duties? They're implied duties by law, because every express contract can't cover every possible situation. So I want to go over a list I mentioned to you before a second ago that errors in plans cause problems. So there's an implied warranty under what's called the Spearman Doctrine that when an owner prepares plans and specifications, the contractor, and therefore the subs and suppliers, have a right to rely upon these plans. Once these plans are prepared and approved, then the owner is responsible. Even if the job becomes defective or there's workmanship problems that develop because of bad plans. Now, if you didn't file the plans, you don't have a defense. But if you file the plans and the plans, for example, don't show the concrete thick enough, or it doesn't show the structural calculations of a certain part or the HVAC measurements of windows, anything like that that the plans are incorrect about, that you filed to your detriment and relied upon, is really the owner's problem, even though they'll try to turn it around on you. So when the errors on plans are discovered, you want to make sure that you realize as long as you perform per plans and specs, you're protected. Even if you don't perform per plans and specs exactly. I read an article, I don't know, probably like 10 years ago, 15 years ago, on the plane as a member of the American Bar Association Construction Reform Committee at the time. And that article was fascinating to me because I was developing a project at the time and we were having problems. And I read very carefully. What happens when you don't follow the plans and specs? Does that mean you're wrong? No. That means if you don't follow the plans and specs, you can go to your engineer or your architect, have them present an argument of alternative plans, present them to the project engineer and architect. And when you do that, those engineers and design professionals work together and usually solve the problem. I had a terrible situation where there were some structural calculations on a project that one of our clients was involved in. And by us identifying the problem while the project was just beginning, we were able to have our engineer for the contractor sit down with the owner's architect and engineer and the city and get approvals. So just because plans and specs aren't followed by you doesn't mean you're out. But if you don't take those steps and you make the installation without following the plans and specs, including the opportunity to cure it by the process I just mentioned, by substituting your engineer, teaming with their engineer, and getting a mutual approval. If you don't do that, then almost as a matter of certainty, the person who will be deciding the case or the person that's negotiating with you will tell you, you provided defective work and installed it without the consideration of getting your plans approved or your work approved. And you've created yourself a problem. So that's the roadmap when you're having issues, when you're dealing with plans and specs. Under the law, the Spearman Doctrine says that the owner is responsible, and therefore all you need to do is follow plans and specs, or if they're modified, bring your engineer and architect in to get the modified plans and specs approved. Now, there's also other implied duties. These are not in your contract. Implied duty not to hinder or delay. Implied duty of the owner to coordinate multiple primes or subs. Implied duty to provide adequate supervision. Implied duty of good faith and fair dealing. To ensure a safe workplace. To disclose material information to bidders, not to conceal them. To provide accurate plans and specs. To provide accurate site information. To provide the necessary easements, permits, regulatory approvals. An implied duty for owner furnished materials that's compliant with the requirements. Implied duty to timely review contractor submittals and requests, and not to deny requests for valid time extensions just arbitrarily. An implied duty for the project site to be reasonably safe, not to hinder or delay performance, coordinate the contractors, establish implied duties of standards that are in the industry, and to complete the work in a reasonable period of time. So these are the duties that are implied. Another concept of implication of law in your contract comes from what's called the Christensen Doctrine. In the Christensen Doctrine, the United States was working with a contractor, and the United States basically told the contractor that it did not pay the contractors on time, and had certain termination provisions that were required in the FARs, and that those terms were not in the contract. So the contractor said, since they weren't in the contract, I'm not bound by them. And the court said there are certain public policy standards and requirements that are statutory or known to the industry that will always be within your contract. So the Christensen Doctrine incorporates those standards as a matter of law, particularly in government contracts. Then you've got to be careful of whether or not, if you have a contract, whether the terms are waived, which we're talking about. And there's a couple other concepts that I want to make sure that you're thinking about when you're deciding on how to pursue your claim. If you're doing your work and it's not perfect, that's not the standard. The standard in construction, as everybody knows, who's a contractor and supplier in GC, is to be able to do your work in a workmanlike manner and substantially complete your work. Construction is, as you know, is a very chaotic, disorganized process at times, but we're measured by what we do during the performance and finishing the performance. And if a problem comes up, as we'll discuss, how we handle solving the performance. Now, when you're looking at basically today's industry and today's construction contracting process, we've noticed quite a bit that the parties are working in a way where their subs and suppliers are tending to team together because they're getting black and blue sometimes from dealing with general contractors. There seems to be more of a trend of a general contractor exaggerating the back charge against a sub and a supplier in many ways. And that does lead to a larger dispute. So these concepts that, performance precedes payment, you've got to be sensitive to that. Because if you think you're going to get paid before you perform, in this climate, I don't think that's going to be possible. If you breach a contract and they want to make a default against you, it's supposed to be a material breach. Architect certificates, if you're not doing the work, the architect's not going to certify it. And sometimes you may be late, but you've got to fight back if you're late, because just because you're late doesn't mean you don't have a valid excuse. And we'll be talking about some of those things. What happens if the owner doesn't pay you? When can you walk off the project? So those are a few items that we'll, if we have time, we'll discuss a little bit more detail. We are gonna talk first about the risk of the contract. So before you do that, you have to understand, obviously, what your role is in the project. That's important for many things. For example, if you're a general contractor and you're not getting paid and you file a lien, many times you don't have to give a notice to the owner because he has a general contract with you. But if you don't have a contract with the owner, then you, as a sub or a supplier or sub-sub or supplier to a supplier, if you're covered under those state laws, you do have to give notices. So first of all, identify your role. Second of all, as you can see by this chart, which all of you know, working on a job, who are you extending credit to? Your subcontractor of your supplier, to the GC? No, you're also supplying credit to the project directly to the owner, as this example shows. So when you are extending credit to your customer, what our legal compliance program recognized and basically is known for is we know how to help you extend credit in multiple steps against your customer, secure yourself, and then how to also secure against where the money's at, from the owner, his loan, the escrow company, through the GC, and the sub, back to you as a supplier. Where is your project? As you're going to see in a couple examples I'm going to give you, you're going to find that different state laws treat you differently. And what kind of project do you have? Is it private, public, or federal? Because the laws are far different in those environments. So for you to avoid court and be prepared for your claim, you have to have a powerful contract and a powerful policy in place. So I believe in negotiation and have yet to have myself to go through a trial, even though my legal network around the United States, we have lawyers in all 50 states. Each of the law firms we hand select and work with them, some for more than 30 years, are trial experts and litigators. My philosophy, my clients don't want to be in court, they want to avoid court if at all possible. To avoid court, you have to be prepared. That's kind of the secret to our success in order to be able to avoid risk. Now, what are the risks that we see before we look at the construction contract? Let me show you here. The other day, a client called up on September 11th, approximately 2 weeks ago, and there's a voluntary petition filed on behalf of a general contractor working in New York, Hollister Construction Services. And as soon as they filed Chapter 11, they went right in for their money to operate their cash with an order to pay their bills. And then they went ahead and they're looking for interim orders. And you can see that quickly in the last 2 weeks, there's already been, in this bankruptcy, 115 filings, okay? So litigation gets this is 2 weeks, okay? Very expensive quickly. What happened with our clients in this situation? These were some of the people who are listed on a creditors list, the top 20. Look at the dollar amounts that they're owed and what kind of businesses they're in this recent bankruptcy. And here, the bankruptcy lawyer that represents the debtor basically told our lawyer in Delaware for this job in New York, the bankruptcy was in New York, that we wanted to reclaim goods. And he basically said, please be advised the debtor had outstanding secured debt of $14 million to the PNC Bank, and basically all the assets are secured by the PNC Bank. We're going to show you how that statement's probably wrong. Accordingly, PNC Bank's pre-petition liens are superior to any reclamation claim or other claims, okay? And basically, he hasn't received our mechanics lien yet, but we also wanted to make sure we did a reclamation claim. So what's happened is, when a supplier like in that situation sells a subcontractor or general, and a bankruptcy comes in, right away your policies that we're talking about here are being basically inaugurated into a situation where they end up getting, okay, to a point where they're very important to see exactly how well you're prepared. So I think the trick when you find yourself, when your customer files bankruptcy, is to have done your homework beforehand. So let's go through exactly the steps as you get your contract together. So when you win a construction claim, and we're working here, did you bid your job realistically? Did you negotiate the contract language to prepare for these claims that develop? And have you incorporated a standard contract review? And are you managing, as the job progresses, the tasks and performances? And are you proactive? That's really the key. So in the subcontract clauses, as you know, scope of work, what documents define the scope of work, how is the contractor to be paid, how is the owner assuring himself that the contractor is doing the work properly, what's being done when problems develop. So our goal is to avoid litigation because of all the problems that go forward. I don't want to emphasize the issues with litigation. Many of you probably have experienced it. That's maybe why you're here, is learn how to win a construction claim and avoid litigation. But the owner, when he finds he discovers his water's leaking on his carpenter's walls, sues the architect for designing defective flashing. He sues the general contractor for poor workmanship and breach of contract. He goes after their bond. He'll file a claim against the flashing subs theory under a third-party beneficiary and the manufacturer of the windows. And then the architect's contract with the owner may require arbitration, so then the owner is forced to proceed against the rest of the parties in litigation in court. So there's a separation of liability, which is never a good thing. You know, people ask me, and we'll talk a little bit more about this, but is arbitration better or litigation? And really, in construction, litigation probably, sadly, is the better choice between arbitration when there's multiple parties that are liable or at risk for these policies. When you're in a construction claim, if it's just a payment claim, it's usually the parties without insurance carriers. But if an occurrence occurred and there is insurance involved because of defective work that triggers it, then litigation is the preferable route for sure, other than arbitration. But arbitration may work. The best solution is direct negotiations, or if that doesn't work, to bring in a mediator, I believe. So contract documents, when you sign a subcontract, requires you to look at an owner's contract, the general conditions between the owner and the general, the plans and specs prepared by the architect, the schedule, the quotes that you provided, the amendments, some letters of understanding, and of course, change orders and email. Then other documents that are developed into a claim is typically these documents that you are familiar with on every project, and we are, as lawyers, familiar with through electronic discovery. So there are requests for information, change orders, submittal logs, payroll of your labor, vendors, materials, all this information, notice of defaults, consultant records, inspections, and then third-party records such as a lender's loan file. Why would a lender have made a payment unless somebody certified to him that the work was done in compliance with plans? We've seen recently many contractors go in with owners, obtain millions of dollars of money, certified that everything's compliant, and then somehow think that they can keep the money when they're entitled to a 4%, 5% fee and offset the whole amount against a subcontractor who did the work according to the reason they drew it by getting certified architectural drawings in the plans. So when you're signing a subcontract, there are flow-down clauses that typically you're bound by. So when you're looking at those clauses, particularly payment clauses, which we'll talk about today, we'll see how that works. The formula for avoiding litigation is a great relationship at the start of the job, mutual trust and respect, prior good relationship continues between the parties, time is of the essence, respectful to each other's schedule, and willingness to kind of like overlook contract formalities. If you feel that this scenario, as you know, of a business relationship breaks down, we strongly suggest you begin reaching out to make sure you've done your compliance. This is one indication that, you know, the fact a claim is going to be developed and you're not going to probably be treated well near the end of the project. So the best case you file is the one you prepare for. That you don't is the one you don't file. So when you're working in construction, we mentioned that you're extending credit to a project because all your money is being held up by other people in the beginning when the draws are going on, and not just your customer. So the payment mechanism is really key. A mechanic's lien protects you, as many of you know, because it provides you the security of the debt and provides you to be in a position of secure creditor and kind of evens out the odds. The thing that I've noticed in the last 30, 40 years of practicing is that the discharge of lien bonds, while they're convenient, and we like them as lawyers when we're foreclosing, because the bond discharges the lien and it's easier to go after and there's no longer necessarily a fight with the lender. The frequent use of these discharge of lien bonds are becoming an excuse for other people not to act in good faith and to hold your money. So when we're talking about payment, provisions are very important. The most important thing that you're seeing in subcontracts today are GCs are trying to ask subs to allow them to get paid only if they get paid, not when they get paid, and not within a reasonable period of time. A pay if paid clause is a condition precedent that absolutely requires payment from the owner before the GC has a duty to pay a sub or supplier. You fight that, I'm sure, in every one of the general contracts. If a pay if paid clause creates the risk of shifting the risk of non-payment from the general contractor to the owner, okay, if you're a subcontractor. A pay when paid clause is a payment condition that establishes a timing mechanism. That means that you will be paid when the contractor is required to pay you or when the owner is required to pay him within a reasonable period of time. The difference between a pay if paid, which means I'm never paying you until I get paid, or a pay when paid clause is whether the contractor has a duty to pay the subcontractor when he receives payment from the owner. The case of West Fair Electric in New York versus Aetna is an excellent case because in that case, the court ruled in New York that subs must be able to take advantage of lien law and therefore ruled if the pay if paid provision that I'm never going to pay you till I get paid are unenforceable according to the court because they're contrary to public policy. The reason it's contrary to public policy and what that means is if a pay if paid provision governs the relationship, the owner never makes payment to the contractor, the sub would never have a right to payment and thus would never have a right to file a lien. So the New York case of West Fair Electric Construction versus Aetna is a leading case that says it's against public policy in New York and other states to have a general insert a pay if paid clause. So they can't say in New York and many other states that I'm only going to pay you if I get paid. But what if you're not in New York? For example, I was working with our Georgia office yesterday and asked them, how does Georgia law treat subcontractors? Unfortunately, in the case of Ratsinas Construction versus Triad Drywall, where the subcontractor said that it relies on payment of the owner and not of the contractor, then because of the unequivocal language, the court ruled that the subcontractor doesn't have any right to sue the general until they get paid. Luckily, in this case, though they lost in the appeal court, they end up getting paid a couple years later when somehow the GC did get paid some money from the owner. So when you're looking at clauses in a contract, and we don't have time in the 30 minutes that we're going to give the program today, but liquidated damages clauses and waiver of consequential damage clauses are effectively thrown at you just like the contingent payment clauses. How do you deal with that? Well, owners and GCs set the precedent and then they pass them down to you. My best recommendation is say no, and you won't get the job sometimes. If you have to say yes, the trend right now, which is very important, is get your liquidated damage clauses and your consequential damage clauses or any other damage capped. So usually 1 or 2% of the contract, maybe a little more or less. So if you had a $5 million contract and you had 2%, you basically would have, let's say, $50,000 of, or $25,000 or $50,000 of liability. No one's going to object if you're agreeing to liquidated damages to a cap if they're being reasonable. And you might as well find out whether they're being reasonable before you start working on the job. You'll get a sense of the business relationship if you haven't worked with a general before. And when you start capping liquidated damages, which one of my clients didn't do about a year ago. He was sued for $1.5 million in liquidated damages, and he really wasn't responsible, but that was the argument that they were making. If he would have capped the damages to 25 or 50,000 or even 100,000, then that same contractor knows he can't spend a lot of money chasing that little bit of liability versus an uncapped claim of liquidated damages that they can throw at you. So it's really a very recent trend that I've seen. Please start looking at how you can cap your damages, not signing these provisions broadly, because they are making you sign these subcontracts with a provision in them if you want to work, because they sign them. So the court, in a recent case in Massachusetts, put an insight into these kind of clauses. It said liability for consequential damages can be waived, and these clauses limiting liability will rarely be found unconscionable in the absence of oppression and unfair surprises. So you, as risk managers, take note, people that want to protect themselves, that the term of the contract can include a limitation on damages, therefore limiting your liability. So the issues that we see in construction disputes are payment, performance, extras, sometimes negligence going down, and particularly termination on the bottom. Those are the main ones. Then you see that's covered with insurance, professional liability, malpractice, and negligence. No matter what position you're in, you want to be in a position to negotiate, okay? And negotiation sometimes is done through mediation or arbitration even, and during litigation, during pretrial. Somehow 95% of all cases settle, so the negotiation factor is important for you to be prepared. When you're working together with your suppliers and subs, teaming together adds value to a strategic relationship. Those values should be maintained when you're filing claims. Hopefully your sub or supplier, you're working together to get the information and create the possibility of lessening risks. Electronic discovery is really, when you get into litigation, so expensive, it's hard to even explain. What's discoverable? Your hard drive, your data storage, offline data storage, fixed drives, programs and utilities, and logs of internal system modifications. So if you're not able to negotiate your way out of a claim in the beginning of the problem, this is what you're facing. Basically, having lien rights, payment bond rights, which many of you know about, having performance bonds on jobs assure you a little bit more protection, but they don't always solve the problem. Sometimes provide more strength to the other side who feels that you have a bonding company on your side if you have a performance bond, or you, on the other hand, feel strong if you have a payment bond given by the general or the sub to collect your money. So when you're reviewing your aging sheets, your receivable sheets, and you file your notices and done everything correctly, you're in a better position to be paid by making sure your lien rights are good. The way you win a construction claim is, from a negotiating standpoint, is you have a transaction which has a very good contract. That's why we went over today quickly the payment provisions and capping your damages. And there are many other contracts provisions that you have to be careful of, as you know. And when you're doing that, you basically have a decent transaction. Then the power comes in conjunction with when someone files bankruptcy, for example, or foreclosure, or they're just messing with you, having your leverage with your liens. So we believe that transaction plus power, which is enforcing your liens and all your statutory remedies, and you're enforcing the implied duties that I mentioned before in a contract, then transaction plus power of law and protection of remedies equals payment. That's really the secret for winning the cases. In these states, they allow for a lien for a full amount, regardless of whether the owner made payment to the contractor. So the owner would be exposed for payment twice. Like New York, for example, that's not true. But in these states, that is. Cost of collection can be recovered in many of these states. How we work as National Lien and Bond is we ask our clients to fill out, before they do work on a job, and while they're negotiating a contract and helping them, or just after they signed the contract, a compliance sheet. And it's a project data sheet that shows you how will you get paid. So we provide customized services for compliance to make sure that you've taken your transaction plus power equals payment. You've done it within the time period of your lien protection, because that way you establish a policy internally. and then we help you, or just simply help you take your lien protection. And if you need further help, you know, we've had the experience in working with clients like you to make sure you get paid by bringing in when the right team is needed. We believe that the way you win a construction claim is to develop the right team that can help you once you've done the right transaction and you've taken all of your leverage and statutory rights to protect yourself. And that team can change depending on what state it's in, who the lawyers are, who the consultants are that bring it in, and also what your strategies are. So when you win a construction claim, you do so as a team, align yourself strategically with the people on the project, because generally, unless somebody's acting very unreasonably, which sometimes happens, everybody really wants a project to begin. It has little chaos and disorganization, and claims and issues arise in the middle, and then work together, sometimes ignoring the contracts, but getting the job done at the end. So every job has a beginning, a middle, and an end, and our job is to make sure we walk you through that process to the extent that you need help, but do so by establishing the policies up front so you know how to get paid. In these states, on the private jobs on the left, in many instances, you're required to do notices, and on the right are the states that require public notices on public projects. Why compliance? Because compliance gets you into a winning position so you can make your claims when they come up, or just your regular accounts receivable, secured and protected. If you follow these processes, then those people that, like the first demonstration I gave you earlier today on September 11th, when Hollister Construction Company went bankrupt, those people that follow the compliance, they get paid. So knowing your lien rights, what's lienable, the class of liens, when you serve, what the time periods are, what a court may consider complete in your state, how you have to perform the contract, and when is a lawsuit, if necessary, after you file, those requirements are important. California, for example, must file notices within 20 days. New York, you can file at any time, but if you do, then if the owner paid out, the general contractor, you're limited to the amount of money left. In Florida, if you have a lien, you've got to serve a notice within 45 days. If you don't, you're out of luck. You lost your lien rights entirely. So I want to thank you for attending our 30-minute seminar on how to develop the strategy to win a construction claim, be in a position for you to go ahead and do your transaction, plus your power of following the laws and the remedies that are available to you. And when you do that, you will be paid. So thank you very much, and we'll look forward to following up with you if you have any questions. There may be some question and answers on the, if there are, on the chat or something that you can optimize, and if you do so, we'll be able to answer them. Thank you so much for spending a half an hour with me on the subject of how to win a construction claim. Have a nice day.